Welcome to California Virtual Family Law Attorney with founder Linda Garrett.
Hello, everyone. Welcome to California Virtual Family Law Attorney with founder Linda Garrett. Linda's been practicing family law in California for over 20 years, and she's the founder of the law office of Linda C. Garrett, based in Solano County. Through both traditional representation and family law legal coaching, she helps clients across California understand their rights and make informed decisions about custody, support, and property division. My name is Sean O'Connor, and today Linda and I are taking a look at how child support is calculated in California. Linda will explain what actually goes into the numbers and what factors matter. It can be confusing. Hi, Linda. How are you?
Hi, good afternoon. Thanks for having me on the podcast.
What formula does California use to calculate child support? Like, what are the main components of it?
You asked a loaded question. So, starting about last year, we have this new software that we have to use called Spouse. It looks kind of like an Excel spreadsheet. Puts in some numbers, it spits out a number, and that's known as guideline. I actually call it guideline child support. And that seems so easy, right? You plug in this, how many kids. And so the factors that the software would have is, for example, number of children. What is mom's income? Gross from all sources. What is dad's income from all sources? Other factors, their heavy hitters are percentage of visitation for the non-custodial parent. That's the person who has less than 50%. Like every other weekend parent would be the non-custodial. Other factors would be, is somebody paying mandatory retirement into CalPERS, or are they paying voluntary retirement into their 401k? And any deductions such as interest on the house, the taxes on the house, and other things as well. So they're just numbers, basic numbers the courts needs. And that's what's known as guideline support, meaning we use the software, plug in the numbers, and the software spits out a number of what the non-custodial parent should pay the custodial parent. And everyone have a nice life, and you know, and what's that phrase I use with the end of each Disney movie, and they live happily ever after. Well, no, it doesn't happen that way. The biggest issues we find are, what are the incomes? What do you do if someone's not reporting at all? What about the person who works cash under the table, cutting hair, doing tattoos? That's where the problems come in. So what should be a 10-minute process can take months, if not years, literally, to deal with these issues. Because now we're conducting discovery and subpoena, bank records, credit card statements, investment accounts, Cash App, Venmo, PayPal. So it's either simple, easy peasy lemon squeezy, or it's the other extreme. And then we can have a trial, just what is visitation? And they're fighting about that because the parties know, as is the law, the person who has the children more is typically, not always, but typically the receiver of the money. And the more time the custodial parent has, guess what? The more money the non-custodial parent pays. So it's easy in concept, but a nightmare in practice, statistically speaking.
Yeah, I mean, I get it there. You know, whether by, some people's situations are just complicated, just inherently. I mean, I can relate to this, right? Where, I was thinking about, the way income gets defined, for child support purposes, obviously, is, if you're self-employed or you have fluctuated earnings, I wasn't in California at the time when I was dealing with this, but, that describes my scenario to a T. And I wasn't trying to hide anything. It was just a matter of, it wasn't as simple as, well, here's my 1040 or whatever,
Oh, absolutely. Exactly. And so that's where we have the problem. So for my listeners or viewers, the common things that I see is not reporting all the income. And so the challenge is that somebody fills out a form called an income and expense declaration. And then most times they will attach their 60 days worth of income from all sources, because that's the law. Now,
Yeah.
what we end up getting is this one case I have where the wife has $1.9 million in investments. She's 72 years old and she doesn't want to take her money out. She has a house that's paid in full and no debts, and she wants her 75-year-old husband, ex-husband, who had Agent Orange in Vietnam, to pull from his retirement. So the point being is she didn't attach anything because she was hoping to trick the courts as well as trick my client before he hired me. So we see a lot of deception. And so the common things are where people are not disclosing all their income as interest income from investment. So it's a zero. They don't include net rental income. They think it doesn't matter. Um, Dividends that they reinvest. Um, and these are all things the courts need to know. And that is a challenge. So I'm not sure what your experience is, but if someone's not done a properly prepared income and expense declaration, when I see it, I kind of take it with a grain of salt. That's my starting point. Like,
Yeah.
oh, okay, that's your name, that's your age. Okay, I won't dispute that. But now we have a husband who doesn't have the kids claiming head of household. Um, and those matter. And all these things I look
Yeah.
at when I'm helping my clients.
If my child is living majority of the time or living more, you know, at her mom's, my support payments are likely to be higher. Like that's kind of a given because the expenses over at that household are going to be higher, and I need to support that. What happens? And you kind of touched on this with the tax versus weekly pay stubs transparency. What happens if one parent believes that the other is underreporting, or is not being transparent? Is that, you know, I imagine too, like people's situations change, right? Like, okay, you get a divorce, you go through everything and you get your child support payments and all that stuff set. Let's just say it's January. And then, 6 months from now, one or the other, you know, parent gets a new job, big, big, big promotion.
Yep. That is a change of circumstance. Again,
Oh,
and when it comes to child support, the increase doesn't have to be that much. If I recall, like, I don't quote me, but I think it's as little as 5%. But
mm,
usually when people come to me or go to court, it's much more than that. But that happens. So what I tell people about orders regarding children, they're never considered permanent. Like if you get divorced, that's permanent. You have divide the cars and houses, permanent. But when it comes to children, we at best we call them final, meaning this is as good as we get for today, and these are the laws and the facts for today. But then 6 months later, right? Somebody lost their job, somebody got a new job, somebody got married, all those things. And so when it comes to children, we don't have permanent orders. The only time it becomes permanent is when the child is 18 and graduates high school. Again, there are exceptions to the rule, but that's
mhm.
the 90% rule. If this kid is 18, graduated high school, good riddance. And one point I do want to make, just because it comes up so often, is, well, what happens, Miss Garrett, if our child's 18 but wants to go to college and they're still at home and I can't afford to take care of them by myself? Can I ask my husband for more support? No. You can't. Now at that point, you're voluntarily, as a really loving parent, to continue providing care for your adult child. Because technically
Yep.
speaking, you can say, "Bye, Joe. Go get a job. I'm done." And some
Yeah.
parents actually do that the day after the child turns 18 and graduates high school.
Yeah. What about things like, I mean, this isn't college. This is, we're still dealing with minor children in this scenario, but,
Yes.
how
Hmm.
does the court take into account expenses like, say, private school tuition or extracurricular activities, which can be, very expensive?
Yes, there's essentially three tiers, if you will, to child support. The first one is called guideline. That's where you just plug in the numbers and party A gives X dollars to party B. And for the record, it does not have to be spent on the kids. From the courts and the law's perspective, that's reimbursement. So now mom can go get her mani-pedi and go to Cash Creek and buy some shoes. That's the way the court sees it, as a reimbursement. So Guideline is just more of a reimbursement to mom while she has the children with her. The next tier would be mandatory add-ons, which are on top of and not a replacement for, which is things such as necessities, such as mom needs to have daycare to get a job versus mom needs daycare to go shopping all day and watch TV by herself. No. If it's an essential, it's considered a mandatory add-on so that, for example, if father's ordered to pay 300 a month, no, that's too low, but 1,000 a month, then that 1,000 you add on about 50%. That's a general rule of thumb. Everything I tell people, I say general rule of thumb is what I'm talking. Your facts
Yeah.
may be different, but as a general
Yeah.
rule of thumb, they'll then add on 50% of the daycare, which is another form of mandatory support. The other mandatories will be little Johnny is flunking math, and if he doesn't get his grade up, he's going to have to repeat the school year. So then we have to put
Mhm.
him into some tutoring after school. So that would be another mandatory. The other tier then is discretionary, and the courts do not have authority on ordering discretionary expenses for a child. The court has authority to confirm an agreement. The parties, me and the father, have agreed that we will continue to pay our son Johnny, who just turned 18, graduated high school, his tuition for the next year. And maybe the courts might add that on as a discretionary, as agreed to between the parties. But things like piano, karate, gymnastics, private
Yeah.
school, if the parties both believe in a private school and it's that important to them, sure, they'll ask the court to make that into an order so that one of them can't change their mind. But there's no mandatory law of private education. So that'll be in the third category. So
Yeah.
guideline,
That discretionary.
mandatory add-ons, and then extracurriculars. Most times, did not fall into the discretionary.
Hmm.
Yeah.
Yeah, that makes sense. I was curious about the private school. That was a situation. I had that situation where
Mm.
our uh, um, we agreed that we wanted our daughter to attend private school, but it wasn't. It was our decision. It was part of our agreement,
And
and
that's totally
you know,
fantastically great. Yes.
yeah,
Where the problem comes in is that when down the road, some parents says, well, now I changed my mind. And that could be for
yeah,
dozens of reasons. The school's tuition is just way too expensive. Somebody's income is less. And that's if you guys can't reach an agreement, then that person has to go to court to have that portion modified. But that's the thing bottom line, the takeaway for this podcast episode is when it comes to support issues, it's a moving target. There is
yeah,
no permanent. Things continually change. The parties change in dynamics. One minute they're kumbaya, next they're fighting like cats and dogs.
yeah.
Back to kumbaya. It's all over the place. And there's
Well, and
millions of what ifs. Well, what if this and what if that?
yeah,
And I'm like,
yeah.
yes.
Well, and going back to our very first point, or
Hmm.
was this what's in the best interest of the child?
Yep.
That's shifting. I mean, it's literally human development, and a teenager has different situation than the
Yeah.
toddler in terms of visitation, in terms of
Yeah.
needs, in terms of expenses, in terms of discretionary versus it's so just thinking of it that way, I understand what you mean. Where like
Mhm.
there's no black and white, one size fits all situation. Yeah.
No. And essentially, what I tell my clients is there's only two ways, two, to resolve anything regarding your family. Either
Yeah.
A, an agreement of the parties, which is what I always encourage and what I emphasize in my coachings, or B, you take it to court and the judge
Yeah.
decides. That's it. But what about this,
Yeah.
Miss Garrett? Go, no, well, agreement of the parties or the court. What about that? Like, what did you say? And that's
Yeah.
it. And that's the
Yeah.
bottom line. And then the judge will apply the laws, look at the facts and the evidence, not the allegations, to
Right.
determine what changes could or should be made. And the hardest
Okay.
thing, I think, in a divorce case, also speaking from experience that I've been divorced myself, is that it's an adjustment where your brain literally can take years to realize you have less income. and that person wants, well, I want more money, and he's now doing this, and it's just
Yeah.
it's hard to people to understand. You want a divorce, but you want things to stay the same. And so I have cases where the parents live in the same house and they make about the same income. And one of the parties wants to file for child support. And that does happen. But in their mind, somehow they still want more money, even though everything else is equal. Father's an equal parent. They're both in the same house. They're both splitting the bills. And it's just, I learned something. Well, no, I was shared this one piece of advice that I've said forever now. And it was me having a glass of wine, but this woman, we were sitting at sharing a glass of wine, watching the fire. And I went to some baking class for King Arthur. I love baking. And she's, what do you do for a living? I go, oh, I'm a this. And she says, oh, I'm a criminal attorney. I said, oh, family law. She says, oh, I used to do family law. I said, oh, good for you. And then she says, you know what I learned? I said, what's that? She goes, I learned this, that in criminal court, bad people show their best side in court. And in family court, really good people show their worst side. Is it? Ah, you are so right. The things I
Interesting.
have seen people do that are normally
Yeah.
normal people blows my mind.
Yeah.
Blows my mind.
Yeah. And it's, yeah, I mean, immediately, I'm conjuring images
Am
of
I
bad
pushing a
television.
bit?
No,
Yeah,
no.
sorry. Okay.
My
Yeah.
scenario, A, is way in the rearview mirror, and B was completely amicable, all good. But like in so many of these conversations, and you talk about the scenes and the scenarios and the human
Oh,
behavior we
yeah.
witness, it's like there's bad TV that covers this. Like we know this happens. So
Yeah.
anyway,
So
Linda,
there's some light. Let me kind of move a little bit
yeah,
here.
we're out of time, and we'll talk again. It's good to see you.
Thank you. Same here.
That's it for today's episode of California Virtual Family Law Attorney with Linda Garrett. If you would like to learn more about Linda's family law legal coaching or traditional representation services, visit her website, lindacgarrettlaw.com. Thanks for listening, and don't forget to leave a review or like this episode or subscribe so you don't miss any future episodes. I'm Sean O'Connor. Have a great day.
Bye, everyone.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.